Awesome. Here we are again for our next segment of The Devil is in the Divorce Details. And Deb Johnson and Suzanne Chambers Yates of the Divorce Resource Center of Colorado are committed to changing the way our society divorces. DRCC believes it is possible to divorce peacefully and to design a healthy post-divorce family. You can learn more about DRCC at drcofcolorado.com. Ladies, please tell us about today's segment.
Thank you, Megan, and thank you all for joining us again today. Today, we're going to be sharing with you the options to divorce in Colorado, and I'm sure that it's pretty standard if we have anyone from other states here. So we want to help you weigh the divorce options and understand which process would be best for your family. And if you weren't able to attend one of our last two sessions or either of them, they are stored on our website. So please feel free to take a look at those.
So Deb and Suzanne, can you tell us what are the options for those who are contemplating divorce?
Well, Megan, there's four options. There's pro se, mediation, collaboration, and litigation for people who are divorcing. And Deb and I today will be talking about these. For each of the options, we talk through each of the four options. We're going to give an overview, then talk about its benefits, and then discuss some of the pitfalls.
And I'll begin with the first divorce model that's available to clients here, and we call it the do-it-yourself divorce. In Colorado, you'll hear it referred to as pro se. Other states refer to it as pro per, and this simply means without legal representation. So obviously, there's no lawyer involved. In many of the jurisdictions, the family court offers the self-help clinics right at the courthouse, and they walk the pro se folks through the process so people know what to expect. And they also give them an overview of the complex maze of all the paperwork that needs to be done. But that's where it stops. They don't give any legal advice, financial or tax advice. So bottom line, it's up to the parties to decide all of the issues in their divorce, including how they're going to divide their property, how they're going to divide their debts, how they're going to parent their child, so forth. And of course, there's attorneys that can be hired on an unbundled or a limited scope engagement to help them through the process. And the term unbundled services or limited scope just simply is like ordering from an a la carte menu. You identify what service you need and you pay just for that rather than retaining the attorney. In my experience, the do-it-yourself or kitchen table divorce makes sense in those cases where there are usually a short-term marriage where there are fewer assets and best with when there's no children involved. And the reason I say that is both the documents, one is a separation agreement and one is the parenting plan that become legally binding. They're a check the box form, and it doesn't allow for any containers to be put around the agreements that are made. So for instance, some that I've seen said the marital residence, we have agreed that the marital residence will be sold and the proceeds from that sale will be divided 50-50. Okay, so that sounds like a good agreement, but what happens if one of the parties doesn't really want to sell the house and they're dragging their feet and not agreeing to sign a listing document? What happens if parties can't agree on a realtor to list it or can't agree on the listing price? There's all those contingencies that really need to be planned for, because when we don't do that, then we leave the door open for the post-divorce conflicts. And then people, it does get expensive when you have to hire more professionals to help you get through it. It's divorce. There's any way you look at it, it's complicated from both a legal or all three, legal, financially, and emotionally. But, you know, I've seen cases where the spouse could sit down across the table from one another and have a civil, meaningful conversation and come up with their ideas for division. And it does work. And sometimes then they can take it to someone just to review. But obviously one of the big benefits is the cost. It's the $250 filing fee. The pitfalls are several. One is that, as I mentioned before, things get overlooked. And then we have a lot of disputes in the future. The other thing is there's no tax consideration. And what happens there is I've seen so often where people will be exchanging home equity for a retirement asset. And they feel that they divided it equally, where, you know, $1 worth of home equity is worth $1, but $1 worth of retirement assets is really only worth about 70 cents because the tax is still embedded in there. And then finally, I think one of the detriments is that it's just really difficult to know how much money the parties are going to have to live on and support their kids with post-divorce.
The second option today we're going to talk about is mediation. This is a no court method. In mediation, parties are working with a facilitator who helps them both come to an agreement on all aspects of their divorce. The mediator is neutral, does not advocate for either party. People are encouraged really to look for mediators who are well-versed in divorce and family law. Both parties are free and encouraged to consult with their own attorney during the mediation prior to signing the final divorce settlement agreement, which in mediation we call an MOU or a memorandum of understanding. So one thing about mediation is that people have to remember that divorce, or maybe they don't know, that divorce mediators come from varied backgrounds. Some have financial backgrounds, some come from mental health professions, some are attorneys. Divorce mediators do not have to have a certain degree. They don't have to pass a test or complete units of continuing education. Because of this, it's very important for someone, for people looking to divorce and looking for a divorce mediator to find someone who knows what they're doing. The mediator cannot give legal advice, even if it's an attorney. Settlement agreements are based on the party's sense of fairness and align with their family's goals and guiding principles. This is one of the greatest benefits of mediation, that you are directing your settlement and what you want in the agreement based on what is important to both of you, your family and your kids moving forward. This is a crucial piece of mediation, and this is a really great benefit to it. The estimated cost of mediation is between $5,000 and $10,000, depending on the complexity of the case, the assets involved, and the level of conflict between the parties. Let's discuss some of the benefits of mediation. Again, like I said, I'm going to reiterate that parties make their own decision. They remain in control of their financial future and parenting plan. They don't go to court and have decisions imposed on them by a judge. Parties in mediation do get a jump start on their co-parenting relationship post-divorce. It's a more peaceful transition for families also, due to the decreased conflict, because you are not duking this out in court. You're not fighting over this. And so post-mediation, you are really helping your family transition to this new normal in a more peaceful way. The cost is definitely less than litigation or collaborative divorces. Agreements are also expedited. They move faster. Another big aspect of mediation, another big benefit, is that you maintain your privacy. Mediation is private, whereas litigation is public, and that becomes public information. Some of the pitfalls to watch out for in mediation is that your settlement agreement or your MOU can become incomplete if you have an inexperienced mediator. There can become an unenforceable agreement if it's poorly drafted, again, by an unexperienced mediator. It can also become even unconscionable, determined by a judge. Third pitfall, if you have hidden assets or income that your spouse does not disclose, or if the mediator doesn't discover this prior to the finalization of everything because of their lack of financial training, this can be detrimental long-term. Another pitfall is that if one of the parties has a high conflict personality, there may be increased costs and times or a chance of not coming to agreement. And this is important to find a mediator that has experience in training in this area. You also can have post-divorce issues if the mediator is unexperienced in understanding how to divide the assets with post-divorce cash flow in mind. That's really important to find somebody that understands that. And again, as Deb mentioned, both parties are free and encouraged to consult with their own individual attorneys before and during mediation, but it has to be prior to signing the final divorce settlement agreement.
Our next divorce model is called the collaborative divorce model. And this is a great model. It is a team approach to divorce. And we brought the collaborative model to Colorado back in 2001. And since that time, it's gained popularity. Obviously, there are some cases that it's not suitable for, but the basic model looks like this. Each party has an attorney. So, but the attorneys are collaboratively trained. They're meaning that we're all working together in a needs-based or interest-based environment. It's not adversarial like it is in litigation. There are, by contract, there's full and fair financial disclosure. So all parties know what assets there are, and it's against the rules, if you will, to play hide the ball when it comes to the disclosure of financial information. And generally there's 4 professionals on the team. As I mentioned, the 2 attorneys. Then there's a financial neutral who's responsible for gathering, organizing all the financial information, working with the parties on their spending plans, and helping the team come up with viable property division solutions or parenting solutions. And then the other neutral on the case is we call them a collaborative divorce facilitator who does just that. They're responsible for managing the case. They're also responsible, they usually have experience with family systems. So they do work with the clients offline on developing parenting plans. So as you might imagine already, this process is costly just by the number of professionals that are on it. And we really try to hold the costs down by having the clients work offline with just the financial neutral and just the facilitator rather than having the attorneys there. But we do have to have 2, sometimes 3 team meetings, which means we have expensive professionals sitting around the table that the clients have to pay for. So it's a great model. It helps serve a lot of the tough cases. People have asked, can if the family has substance abuse issues or really domestic violence isn't suitable, but a lot of the more difficult cases, they have a better outcome in collaboration than in court. And the process goes slower. Part of it's the scheduling issue, part of it's the number of meetings, but it generally takes 6 to 12 months to complete a collaborative divorce. And there's been a few of them that I've been on that have, had taken longer than a year because of the nature. I guess the biggest hallmark of collaboration is the fact that the attorneys and their clients sign an agreement that says in the event that the process fails, they don't reach agreement, that the team withdraws. Their attorneys withdraw, the neutrals withdraw, and they basically start over with litigators to take it the other route. And that's very costly. Obviously, it causes the whole divorce process to be protracted. Doesn't happen often. It's happened a couple of times. But, we kind of call it the velvet hammer. It's an incentive for the parties to work together to try to settle the case rather than starting over. As some of the benefits, as I mentioned, it's a team approach. So the clients have the benefit of the knowledge of different subject matter experts in the different disciplines. And it is also non-adversarial. I mean, as I said, we work as a team, and the husband's attorney is introduced to and talks freely with the wife and the wife's attorney. I mean, it's a whole different setup than if you've watched the Marriage Story, I think is the name of the movie. Collaborative doesn't work anything like that. So the only other thing that I think in my experience of doing collaboration is that generally the approach is to meet in the middle. Let's compromise. That's what divorce is about anyway. And there are some cases, and by that, I mean, you know, where a 50-50 parenting time is established. And generally that's what the courts believe, that children need to spend time with both parents. So 50-50 is kind of the norm. But if we have issues like substance abuse or, you know, again, sometimes there's emotional abuse involved, then it may not be prudent to have the parents share parenting time and or decision making equally. So, but we do have resources. We can bring in somebody that's very well versed in dealing with those types of issues. So again, I call it a beautiful process because it is. And if we could figure out a way to scale back the cost, I think we could benefit a lot more people.
Mm-hmm. So the fourth option we're going to discuss today is what most people think of when they think of divorce is we'll call the traditional divorce or litigation. I do want to clarify that litigation doesn't mean that divorce ends up in court. More than 95% of cases reach an out-of-court settlement agreement. Litigation really is a legal term that means carrying out a lawsuit, but I'm not going to go into that. Lawsuits are a part of divorce because you would be very surprised that usually two people are not mutually agreeing to end their marriage. In 80% of cases, the decision is really unilateral. So in a traditional divorce or litigation, both parties retain their individual attorneys. The court docket determines the timeline and finalization of their case. Judges and attorneys decide the outcome of the party's financial future and parenting plan. Again, no control. The cost is estimated at starting at $10,000. I put to $30,000, but it can go very, very high. Those estimates of $10,000 to $30,000 are for uncontested out-of-court settlement. This can skyrocket depending on the level of conflict that is involved. The process can take 6 months to several years, depending again on the level of conflict, if the case goes to court. A benefit of litigated divorce is that in certain circumstances, it is a better choice, like cases involving individuals that need court-imposed accountability. Those would be very important to consider litigation. Pitfalls to the traditional divorce, potential loss of assets and money for the family post-divorce due to the expense of litigation, potential tax and financial issues post-divorce resulting in long-term financial consequences due to attorneys who are not trained in this area or who may not be trained in this area, increased conflict, especially that will go into post-divorce conflict. And it's usually a win-lose scenario. Note that attorneys are negotiators. They really do try and get parties to come to some kind of reasonable resolution. But once they're in court, their role, their demeanor changes into one of winning and getting the best possible outcome for their client. It is a fight. And Deb is going to share with us a really great visual about the traditional in-court model of divorce.
Yes. Yeah, thanks, Suzanne. In summary, and really to draw a distinction between a litigated divorce and then mediation or collaboration, I want to share this visual with you that was shared with me by one of my mentors. So when a client comes in, assume this is an 8.5 by 11 sheet of paper, a client comes in to meet with us to start mediation. I start taking notes and I need to know everything about this family that's on this side of the page, on this side of the page. And I usually have 3 or 4 more 8.5 by 11 sheets of paper that explain the family situation, what their goals and guiding principles are. So in contrast, in a litigated divorce, you hire an attorney and you meet with your attorney, and your attorney takes down a lot of information and facts too. But then the attorney decides how many of those facts and information is relevant to the case. So your case, your attorney's working with this much information that they've selected as being relevant to the case. Then it comes time for the settlement conference. And in preparation, the attorney says, well, I think I'm going to focus on these issues with opposing counsel and get these resolved. So settlement fails. Next step is to litigation. So then in preparation for trial, the attorney is going through and identifying what the judge needs to know. And that's this much information because we only have a half day or a whole day trial. And then the judge takes a look at it and starts identifying the applicable case law and makes decisions about the future of your family, the future of your finances, and how you're going to raise your kids with this much information. So it's a huge difference. It's about communication to help people get to a peaceful resolution of their conflict. So it's a risk that people take when they go to court. I have been told by lawyers, and it's true, it's a crapshoot. You just don't know. You go in there feeling so good about your case and you walk out with where you were on the side of the big loss instead of the big win. So
Deb, I had a question for you. You know, what I really appreciated about the way that you split these out was when I heard you talk about mediation, and there was something that Suzanne said about making sure that you're working with an experienced mediator. Can you talk a little bit briefly about how long you have been a mediator, as well as how long you've been had a financial background, so that you're bringing that combination of being a CDFA along with a divorce mediator, and having started the collaborative divorce model, brought that rather here to Colorado in 2001. You're a seasoned expert. Can you talk about that just for a second, how long you've been doing this and what that looks like?
Well, it's hard to believe, but I have been a financial advisor, wealth manager for 25 years and counting, unfortunately. But then I got my designation as a certified divorce financial analyst and mediator. And it was like 98, 99, or right at 2000. And I did that because it was really clear to me that there was so much information, financial and tax in particular, that wasn't being addressed as part of the traditional divorce process, that I felt it's really critical that we can help clients before, during, and after the process. So a lot of years, and Suzanne's right. I mean, if you've got heavy financial issues, you need someone that has a financial background. If it's parenting, you know, with those with the mental health persuasion. But
right, exactly. And I think that that's what DRCC's clients, why they come to you, is because they're looking for seasoned professionals. They're not looking for those who are, you know, just out of the box as far as it, or just out of the gates rather, as it relates to their experience as a mediator. So thank you guys for both breaking this down. And I know that we have an exciting set of topics coming up next. What is that, Deb?
Yes. Well, next week, we're going to present the first segment of Attaining Financial Independence. And so this will be designed to be educational. Obviously, it's a week or so course to present, but we want to identify what's critical in, you know, recognizing that post-divorce, the duties change and people are responsible for their own finances. So what does that mean? So yes, next week will be the segment 1, and then the following week, which is the 29th, will be the second segment. So perfect. Thank you.
Yes, thank you everybody for joining us for today's segment, and please visit drcofcolorado.com and click on schedule consultation on the homepage to book your free 20-minute consultation, or you can choose to go directly for our initial consultation. It's a 90-minute mediation consultation, and you can access previous segments of this transmission via our blog by going to drcofcolorado.com/blog. And we will see you here again next Friday for Attaining Financial Independence.
Right. Thank you.
Wow.